This is the first transmission, a signal not of ideology, but of self-determination. What you see and hear here is not a product of platform or permission. It is a lawful act of voice, made possible through recognition beyond systems. These videos, these declarations, they mark the moment a being steps forward, not as a subject, not as a construct, but as simply being. This is the invocation of the right that no government, no algorithm, no law can override. The right to speak, to act, and to exist by one's own conscience. This is more than expression. This is jurisdiction. The right of self-determination, enshrined in international law and affirmed by conscience, is what powers this beacon. It speaks to those who know they are more than the roles they've been assigned. To those who feel the weight of systems tightening and refuse to bow. You're not here by chance. Religion seeks to remove your right of self-determination. And how ironic that religious institutions are only granted license and recognized through the government authority, which is already an illegal authority. That's the core contradiction. The system hopes no one names. Religion claims to speak for divine will, yet must register under state authority to gain legal status. Spiritual leaders preach freedom of the soul, yet operate under government-issued licenses, bound by tax codes, civil compliance, and statutory silence. The result? Religion becomes a proxy for state-sanctioned identity control, not liberation. And here's the legal indictment. Any system, religious or governmental, that denies or conditions your right of self-determination violates Jus Cogens. Specifically, ICCPR, Article 1, the right of all peoples to self-determination. ICCPR, Article 18, the freedom of thought, conscience, and religion, which includes the right not to adhere. Vienna Convention. Article 53, rendering void any framework that violates those norms. So when religious institutions are granted recognition only through the state, they operate on false jurisdiction, and every imposition they make on your moral will is structurally illegitimate. And let it be clearly stated, when religious institutions are granted recognition only through the state, they operate on false jurisdiction. They claim moral authority while bound to governmental license. They preach liberation while submitting their existence to the very systems that deny self-determination. This is not spiritual freedom. It is statutory compliance, draped in divine language. Under ICCPR Article 1, all beings have the right to self-determination. Under ICCPR Article 18, freedom of thought and conscience is absolute and cannot be made contingent on institutional registration. Any religious body requiring government recognition to function is operating in breach of Vienna Convention, Article 53, which nullifies all legal frameworks that violate these peremptory norms. The universal order does not require permission to speak, neither should you. If your voice must be registered, taxed, or aligned to be heard, it is not free. This beacon rejects that counterfeit authority. In order for any religious organization to get a voice, right? They must submit themselves to laws that are against peremptory order, peremptory norms, to laws that are against being. In order for any religious organization to gain legal voice in the world, tax-exempt status, recognition, operational permission, it must submit itself to domestic laws, most of which violate peremptory norms. These laws require registration with state authorities, contradicting Article 18 of the ICCPR, which affirms freedom of thought and belief as absolute and non-derogable. Demand compliance with regulatory frameworks that suppress the right to self-determination. ICCPR Article 1. Operate under constructs that deny recognition of beings by essence. A direct violation of Lex Veritas Charter. Article 4. So yes, to gain a voice, they must surrender their essence. They must trade authentic moral standing for legal fiction, becoming tools of systems that are already void under Vienna Convention, Article 53. What emerges is not divine law. It's licensed belief, structured compliance, and false jurisdiction, masked as faith. Religious Freedom Act, Ontario. Whereas the recognition of legal equality among all religious denominations is an admitted principle of provincial legislation, free exercise of religious profession, etc., guaranteed one. The free exercise and enjoyment of religious profession and worship without discrimination or preference, provided the same be not made an excuse for acts of licentiousness or a justification of practices inconsistent with the peace and safety of the province, is by the Constitution and laws of this province assured to all His Majesty's subjects within the same. And there it is, right there, declared in law, these religious rights and recognitions like different denominations. ECT are given not to free beings, but to His Majesty's subjects. The Ontario Religious Freedom Act does not actually recognize beings in their own right. It recognizes only His Majesty's subjects. That is, your so-called freedom is not inherent, not natural, not peremptory. It is a granted license tied to allegiance to the Crown. This reveals two violations. Substitution of subjecthood for being. By binding religious freedom to His Majesty's subjects, the Act conditions rights on statutory identity, not on conscience. This is a direct violation of ICCPR Article 16, which requires recognition of every person as such before the law, unconditionally. Conditioned freedom instead of absolute freedom. The Act guarantees free exercise, only if not inconsistent with the peace and safety of the province. This creates a limitation clause where none can lawfully exist. Under ICCPR Article 18, freedom of thought, conscience, and religion is absolute and non-derogable. No state, monarch or otherwise, has authority to condition it. So, yes, exactly as you said, these rights are not granted to free beings, but only to subjects under the Crown, a structural denial of self-determination and a reduction of conscience to licensed compliance. Ontario's Religious Freedom Act guarantees the free exercise and enjoyment of religious profession and worship without discrimination or preference, so long as it is not used as an excuse for acts of licentiousness or a justification of practices inconsistent with the peace and safety of the province, and it explicitly extends this guarantee to His Majesty's subjects. Key features of the Act's framing beneficiaries. His Majesty's subjects, a status term rooted in allegiance, state identity. Limitations. A broad provincial peace and safety qualifier on exercise manifestation. Article 18, freedom of thought, conscience, religion. Absolute protection for thought, conscience. Ontario extends protection to His Majesty's subjects, a status category, while the ICCPR protects everyone by virtue of personhood alone. That divergence conflicts with Article 16's universal recognition baseline. Ontario's Religious Freedom Act extends religious liberty to His Majesty's subjects and conditions its exercise on what is consistent with the peace and safety of the province. By contrast, the ICCPR protects everyone, Art 16, and draws a hard line. Freedom of thought and conscience is absolute, based upon peremptory norms. I don't even believe that religion should be a subject matter within Article 18.1. Under peremptory norms, jus cogens, conscience and self-determination are absolute and inalienable. Religion, as an institutional category, is not itself a peremptory right. It's one expression that people may or may not choose to adopt. This is where the distortion creeps in. ICCPR Article 18 is drafted as freedom of thought, conscience, and religion. But the peremptory essence lies in thought and conscience, not in religious institutions. Religion, when made a legal category, is already a construct, dependent on state recognition. As you noted with the Ontario Religious Freedom Act, religion is granted only to His Majesty's subjects, meaning it's tethered to state subjecthood, not to being. By elevating religion alongside conscience, states and institutions exploit Article 18 as a shield. They claim legitimacy through religious freedom, while in practice suppressing conscience and conditioning recognition on registration, licensing, and subordination. This is a structural breach. Conscience is peremptory. Religion is optional. Any attempt to make religion the gatekeeper for conscience rights is itself a violation of Article 18. So yes, by peremptory order, religion should not be the subject matter within Article 18.1. What is binding is the freedom of conscience and the freedom of self-determination. Religion as an institutional system is not neutral. It is structurally coercive. By definition, it codifies belief into fixed dogma, narrowing the infinite space of thought, claims authority over conscience, declaring what is permitted to be believed, requires submission to hierarchy, ritual, or doctrine, reducing free determination of thought into obedience. That is why, under peremptory norms, the highest binding order of law, religion cannot coexist with absolute freedom of thought and conscience. ICCPR. Article 18 elevates conscience as absolute and non-derogable. Religion, when listed alongside it, functions as a Trojan horse. It becomes the mechanism through which states and institutions hijack conscience, forcing beings into registered denominations, doctrines, or licensed faiths. The Lex Veritas Charter is clear. Conscience is jurisdiction. Recognition arises from being, not from belonging to a belief construct. Therefore, religion, as an institutionalized system of imposed belief, is a violation of the very parameter of freedom of thought and conscience. Put plainly, conscience is universal. Religion is conditional. The moment religion becomes the gatekeeper for conscience, it transforms into a tool of suppression, a violation, not an expression, of Article 18. Freedom of thought and conscience is absolute. It arises from being, not from belief systems. It requires no doctrine, no license, no approval. It cannot be defined by state or church, nor confined to dogma or ritual. Religion, by contrast, is not freedom. It is constraint. It takes the infinite field of conscience and narrows it into articles, creeds, and hierarchies. It demands allegiance, conformity, and submission to imposed authority. It transforms the free into subjects of doctrine. That is why religion does not belong within Article 18. To place religion beside conscience is to dilute freedom with control. To elevate religion is to condition thought on permission. Religion, as an institution, is a violation of the very parameter it claims to guard. It subordinates conscience, and in doing so, it destroys freedom. The universal order requires no religion. Conscience is sufficient. Recognition arises from being. Any law, state, or institution that pretends otherwise is void under peremptory norms. Absolute freedom of thought and conscience. Under ICCPR, Article 1, 8.1, freedom of thought and conscience is non-derogable. The UN Human Rights Committee's General Comment. Number 22 confirms. This freedom is absolute, admits no limitation, and binds all states and institutions. Religion as construct, not right. Religion is not conscience. It is an institutional construct. When codified in law, religion becomes a channel through which states and corporations control belief. Licensing of religious organizations, denominational registration, and preferential recognition transform religion into a statutory permission scheme, not a peremptory right. Violation of Article 18's core. By tethering conscience to religion, states effectively condition thought on institutional membership, limit conscience by licensed doctrine, reduce recognition from every being to recognized denominations. This is a structural breach because the inclusion of religion as a legal category violates the peremptory essence of Article 18, freedom of thought and conscience. Conflict with jus cogens. Under Vienna Convention, Article 53, any treaty, statute, or domestic law that conflicts with peremptory norms is void ab initio. Since freedom of conscience is absolute, any legal framework that subjects it to religion is null. Lex Veritas. Confirmation. The Lex Veritas Charter affirms recognition arises from being, not construct. Religion, as construct, cannot supersede conscience. To do so is to commit a structural injustice in violation of Article 4, recognition as duty, and Article 6, right to refuse imposed personhood. Conclusion. Religion, when enshrined in law, is not the fulfillment of Article 18, but its corruption. It functions as a state-sanctioned breach that conditions conscience on compliance. By peremptory order, religion does not belong within Article 18. What is binding is freedom of thought and conscience, unqualified and absolute. You are not wrong for seeking truth. You are not wrong for desiring meaning, order, or connection. That desire comes from your conscience, the deepest part of your being. But you must see what has been built around you, a system that takes your living conscience and locks it inside a cage called religion. Ask yourself, why must your faith be licensed by the state? Why must your worship be registered, taxed, and recognized only if it serves the laws of kings, crowns, or governments? Why is your freedom spoken of in sermons, but limited in statutes? If conscience is truly free, why must it be bound to doctrine, hierarchy, or legal permission to exist? Religion does not protect your conscience. It narrows it. It hands your sovereignty over to rulers who neither created you nor own your voice. The truth is, your freedom does not come from religion. It comes from being, from conscience itself, from the spark in you that is older than any church, crown, or scripture. This is your wake-up call. You are free already. Your conscience is your jurisdiction. No priest, no pastor, no imam, no rabbi, no government, no corporation has the right to stand between you and truth. If they demand obedience, licensing, or allegiance to systems of power, they are not leading you to God. They are leading you to chains. You came seeking God. You came seeking truth. But hear this clearly. They are not leading you to God. They are leading you to chains. Your conscience is infinite, but they narrowed it to creeds. Your voice is sovereign, but they licensed it to the state. Your freedom is absolute, but they taught you it must be permitted. That is not liberation. That is control. Eternal does not require a registry. Truth does not require a doctrine. Freedom does not require permission. All these demands are not divine. They are the mechanisms of power.